want to save that because by the end of the day, you might want to take your clap back. Can everybody see this okay? I got here a little early, and I didn't know the layout of the room, so I hooked into the TV instead of on the screen. So y'all in the back can see that okay? Okay, good deal. Well, I don't really have a lot to add to this bio. I worked for the Real Estate Commission for 20 years. I was an auditor investigator, and my final position there was chief auditor investigator. So I was that scary guy everybody told you about that was going to darken your doorway. And actually, I did come to Bluewater a few times during that 20-year career. But obviously, the relationships weren't horrible because Woody and some of the other folks decided they wanted me to kind of be on your team now, so I am a consultant for your firm. I left a stack of cards by the door, and you are all welcome to take one. And anytime you need anything, if you have any problems, any questions, obviously you want to run that by your BICs, but I'm always available to assist you if you have any kind of problems. All right, if you run into something, particularly if it's something you think might be an issue with the Real Estate Commission, give me a call, and I'll bounce it off of me, and I'll give you my 2 cents worth, which is about what it's worth. But at any rate, those are there. Please, again, feel free. Recently, I started teaching, in addition to my own business, with the consulting part, I started teaching for JY Monk. So I'm not as available as I used to be. If you call me and I'm in the middle of a class, obviously I can't take phone calls, but I'm really good about getting back to people. So if it's something that you don't need an immediate response on, you can shoot me an email. If it's urgent, call me. If I can't take your call at that time, I'll call you back as soon as I can. All right? About 4 years ago, I left the commission, started my own business. So now what I mainly do in my consulting business is help brokers with trust account issues. So I still do the same kind of audits, except now I'm doing it for the brokers so that they know if they have any issues, they can address them, we can fix them, get it straightened out. And then if the Real Estate Commission shows up, there aren't going to be any problems. So that's me. All right, today we are going to talk about designated agency. Pat and I have chatted a little bit, and he's indicated that the firm's thinking this is a direction they want to move. And so we're going to just discuss designated agency, what the requirements are, what it exactly means. But in order to have a discussion about designated agency, I think first we need to just do a general discussion of agency and what that means and how we get from the common laws of agency to designated agency. So bear with me. If you have questions at any point, please go ahead and speak up and let's discuss this. We want to make sure you understand what you're getting into, because if you don't address agency correctly, it can cause major problems. And the Real Estate Commission is really serious about disclosure and making sure people understand what their relationship with the broker is. And so please make sure you're following this, and if I say something that confuses you or you're not quite sure, questions are very welcome, okay? And nothing leaves this room. This is Vegas today, okay? What happens here stays here. I don't work for the Real Estate Commission anymore, and I don't go run to them and tell on people, all right? So don't worry about that. All right, when we talk about agency, and we're going to kind of go back to, pre-licensing again, we have to remember what that means. And when you are someone's agent, you have that fiduciary duty. Okay, so the fiduciary, you're in that position of trust, and that's the big thing. That person needs to be able to rely on you and trust you. They're going to trust that you're going to be honest with them, that you're going to keep confidential information confidential, and you're the expert, and you're going to be able to advise them in a competent manner so that they can really rely on you. Now, this is something where people do get a little bit confused. Technically, the agent is your firm. All of the contracts, all the listing contracts, all the buyer agency agreements, they're not with you as the individual broker. The contracts are with the firm, and they belong to the firm. So the firm is considered the agent, and then all of you are sub-agents of the firm. Okay? So the thing to remember about that is make sure you understand what happens if you leave the firm with the contracts, the listings, the buyer agency agreements. If you leave the firm, what is the agreement that you have with the firm about those contracts? Because you don't just automatically get to take them with you. They belong to the firm. So all of the agency contracts are between the clients and your firm. All right? That client relationship, when we enter into those agency agreements, that establishes that fiduciary responsibility. Okay? And we all kind of remember this stuff. The principal is your client. So again, when we're talking about laws of agency, the principal is your client. The sub-agent is the person employed by the agent. So again, the agent is the firm. We're all sub-agents of the firm. Now, unless you have some kind of agency document or written agreement with the buyer, you're assumed to automatically represent the seller. And a lot of people don't remember back this far. When I got licensed back in 1990, everybody was considered a sub-agent of the seller. So originally, there were no buyer agents. Everybody represented the seller. So even if you only worked with buyers, and you were out there building relationships and showing them houses and meeting their kids and all that good stuff, you were supposed to be representing the seller. So any confidential information that buyer gave you, you were supposed to be giving that to the seller. You weren't supposed to be giving the buyer any kind of advice or guidance that was to the detriment of the seller. Well, that didn't happen in the real world, right? So that's why these agency laws changed back in the 90s, and this was kind of a nationwide thing, because people recognized, hey, this isn't what happens in the real world. You know, we're all supposed to be sub-agents of the seller, but I don't even know the seller. I'm working with these people. I want to get them a good deal on a house. I want to represent the buyer. And so that's when all the agency changed, all right? And in North Carolina, it was about, I think it was about 93, they said, we are going to allow buyer agency, all right? So that's when that all began. Oops, got a little ahead of myself, sorry. So remember, agent is the person who is hired to represent another person. You have that fiduciary duty to your principal, which means they come first. It's not about you, right? And the firm is the agent. We are all the sub-agents. Remember that your brokerage contracts, your listing contracts, and your buyer agency agreements, those are the documents that create that fiduciary relationship. All right? Those documents create that legal bond or that definition, that it creates that agent-principal relationship. The Real Estate Commission requires that all agency agreements be in writing. Okay? So if you don't have a written agreement, now we'll talk about oral buyer agency a little bit, but you can't get through an entire transaction and not have a written agreement with someone. All right? You got to have a written agreement with somebody before you can get to the end of a transaction. That is required by the Commission's rules. And those agreements are going to establish what your responsibilities are, what your authority is to represent that principal. It's also going to dictate what their responsibilities are to you. All right? It's not just a one-way street. They've got some things they have to do for us too, right? If I need to show the house, you can't keep telling me, oh, it's not a good time. Oh, we had a party last night and the house is a mess. Oh, I just don't feel like doing something today. I'm busy. You know, they have to cooperate. So they're making promises to you as well. And again, our documents that we use to create those relationships are our listing contracts, our buyer agency contracts, and in property management, we have our property management agreements. And when we sign those documents, that is our agency contract with that client. Those are also considered our employment contracts. Excuse me for walking in front of the screen. I have to have a sip once in a while. So that establishes not only our agency relationship, those are considered our employment contracts as well. It specifies what we have to do to earn compensation, what the compensation is going to be, that kind of thing. All right? Who pays us does not establish the agency relationship. So that's why, even though if you're working as a buyer agent and the seller's paying the commission, that doesn't mean that you're representing the seller. So that was kind of the old school train of thought when everybody was a seller sub-agent, was since the seller was paying the commission, everybody worked for the seller. That isn't the determining factor. The determining factor is who do I have an agency contract with? And that establishes the relationship. All right, so now with that little bit of background, what types of agency are there? Well, the basics, we have exclusive representation of the seller, where I have a listing contract with that person and I am their exclusive agent, I represent them only. Or I can be on the other side of the transaction. I have a buyer agency relationship with a buyer. I'm representing their interests. I represent them exclusively. Okay? The problem comes about where we have firms like yours where we represent both buyers and sellers. There are some firms that will only take listings. And there are firms that will only work with buyers. But most firms who do residential sales are going to work with both buyers and sellers, okay, which is what we're dealing with today. So what happens when you have a buyer with a buyer agency contract with your firm wants to buy a listing that is listed with your firm? And that is when we get into dual agency. Now, I don't know why to this day this still causes so much confusion with people about what is dual agency. Okay? And the first thing to remember is if there's more than one firm, it's not dual agency. All right? Anytime the one client is with one firm, the other is with the other firm, that is never dual agency, that is exclusive representation. So whenever we're talking about dual agency, it is both clients are represented by the firm. So it kind of runs into this dilemma. My fiduciary duty, my agency relationship, I am supposed to represent this person above all others. And I'm supposed to be working to give them the best deal that I can get them. And I'm supposed to keep all of their confidential information confidential. Right? Right?
Yeah.
Okay. I didn't put you to sleep already, did I? Okay. So how do I do that when I'm serving two masters? Both of these people have contracts with your firm. And we're all sub-agents. So legally, I'm supposed to represent both these parties with the same amount of loyalty and fiduciary duty, right? Everybody remember from pre-licensing what LOAD stands for? Loyalty, obedience, accountability, disclosure, and skill, care, and diligence. Those are our fiduciary duties. How do I do that to two different people that are on opposing sides of a transaction? All right? So what happens, the way I describe what dual agency is think about a football game between Carolina and NC State. Okay? Those two teams don't like each other very much. Do they? No, we got two teams with very opposing goals. All right? They suit up, they put on their uniforms, they go out on the field, and they are going to do everything they can to win. Their goal is to win the game. Each team wants to win, right? And they are going to discuss strategies, and they're going to run hard, and they're going to hit hard. Hey, if the other guy on the other team gets hurt, part of the game, right? And I'm going to come up with plays, and I'm going to try to fool the other team as to what's going on. Both teams are working together, and the exclusive agent in that situation is kind of the coach, right? I'm coaching that team. I'm telling them what to do. I want my team to do the best and to win. So we have these very two opposing goals. And as long as everybody plays fair, it's a good game. You know, that's the way it's supposed to work. But what happens when we get into dual agency? You're on one team or the other. Say I'm on the Carolina team. Now all of a sudden I'm a dual agent. I have to put on the ref's uniform. Okay, so that's kind of what dual agency is. Now all I'm trying to do is go out there and make sure everybody plays fair. Right? I'm not going to take priority one team. I'm not going to favor one team over the other. I'm not going to go over to the state bench and tell them, hey, I overheard Carolina calling their next play. This is the play they're going to run. Right? Because that wouldn't be fair. I have to call the game down the middle. I have to be fair and impartial. And that's kind of what dual agency is. If you are acting as a dual agent, you can't do anything that is going to give one person an advantage over the other. So if I've been working with that buyer agent, or I've been working with that buyer, and they've been telling me all their personal stuff and all about their family, and I've established this good personal relationship. I like these people. I've established this relationship with them. And now all of a sudden, we go into dual agency. Now my entire ability to assist that person has changed. Because I can't give them any information or any advice that is going to put that seller client at a disadvantage. My duty to that seller is every bit as, the level of duty is every bit as high as it is to that buyer. Does that make sense to everybody? So when that buyer starts saying, well, what do you think I should offer for the house? I can't tell you that. I can tell you this is what the property's listed for. I can show you comparable sales. But I can't do a CMA for you that's going to put that seller at a disadvantage. All right? I can't advise you to offer less than what that property's listed for. You're going to have to come up with your figure. All right? I will prepare your offer and I will present it. On the flip side of that, I can't go to that seller or I can't share with that seller any confidential information that I have about that buyer. Okay, is everybody with me on this? It goes the same way with the listing agent. You know, if I know, hey, that the buyer agent told me these people are willing to pay more for this house, I can't tell my seller that. Because that would be putting the buyer at a disadvantage. So anything, remember in general terms, what is considered confidential, price, terms, and motivations, right? If I know price, terms, and motivations about the other client, I can't share that. So if I'm working with the buyer and I know that seller will take $10,000 less than asking price, I can't tell my buyer that. Because that would be confidential information about the seller, and I have a fiduciary duty to that seller as well. So that is dual agency. I'm the referee, and I'm supposed to be impartial and fair and just make sure the game goes the way it's supposed to go, and I don't care who wins. Right? Is that reality? Does that defy human nature? Can I be playing on Carolina's team for 3 quarters, and then all of a sudden they say, okay, take off your uniform, put on the ref's uniform, you're the ref for the 4th quarter. Oh, and by the way, fair and impartial, and you can't do anything that's going to give Carolina an edge in the game. So a lot of people say dual agency is not real. It's not realistic. It defies human nature. You're asking somebody who's been loyal to a person to suddenly change how they feel and how they interact with that person. All right, so that's where we say, how about designated agency? All right, so I think I got ahead of myself a little bit as far as the slide shows. That's what we covered. in order to do designated agency, designated agency is dual agency. Okay, that's one thing a lot of people don't understand. Designated agency is a form of dual agency. So in order to do designated agency, you have to have authorization to engage in dual agency. Dual agency always has to be disclosed, and it always has to be authorized in writing. So as we get into designated agency, you need to disclose that, discuss that, and get it authorized in your listing agreements and your buyer agency agreements. That's where the clients are going to give you permission to do this. If you buy a property listed with our firm and you want exclusive representation, then we will have to engage in a designated agency relationship. Okay? This is something that is really important, that the Real Estate Commission will hammer people for undisclosed dual agency. And this typically should not be a problem. Where we get into this is if you are approached by someone who is unrepresented and you start giving them information about your client. For example, I'm sitting in an open house. I'm the listing agent. Someone walks in. We start talking. I give them an agency disclosure. They say they're interested. They're not represented. And I say, well, I'll tell you what, if you bring me an offer within the next week, I'm sure I can get this seller to come down $10,000 on the price. You know, is that a violation of my duty to my seller? Am I not giving that person information and suggesting to that person that I'm working for them? That would be an example of an undisclosed dual agency. Don't do that. That's bad. Okay? So when we get to this situation, which is what I just talked about, it's like, hey, what do you mean you can't tell me how much to offer on the house? I need you. That's why I came to you in the first place. Right? I want you to take care of me, hold my hand, and help me through this. You're the professional. You're the expert. Now you're telling me all of a sudden you're not on my team anymore. You're the referee. What is this? I don't want that. I want you on my team. I want you to help me win. Right? So that's where we get into designated agency. Now remember, and this is the commission's rules. Every firm is going to determine how they handle this. So, okay. I thought, gosh, who just started talking? You need to make sure when you start engaging in designated agency that you are very familiar with what your office's policies are. All right, because the commission wants this done in a very specific way. So first of all, you're going to make sure you have the authorization for designated agency on the front end. That is going to drive me crazy. All right, because even though the individual agents will be acting as designated agents, the firm is still a dual agent. Okay? All the other agents in the firm are still dual agents. Thank you. I don't like her. All right, so that's something to remember too. So I know Jim and I know Pat, so I'm going to use them as my examples. Pat has a listing. Jim's working with a buyer as a buyer agent. Jim's client wants to buy Pat's listing. We designate Pat as the exclusive designated agent for the seller, and Jim is the exclusive buyer agent for the buyer. Everybody with me? All of you are dual agents. Okay? So the thing about sharing confidential information and all that good stuff still applies. You don't do anything or say anything that would give either client, because remember, they're both clients. We don't want to give do anything that would give either client an advantage or a disadvantage in that transaction. So it's still dual agency. The firm is a dual agent. All the other agents in the firm are dual agents. But Pat is going to exclusively represent the seller, and Jim is going to exclusively represent the buyer. They stay on the team. Okay? Both sides are still going to be represented by the firm, the commission's rules say the broker in charge is going to designate each designated agent. All right. Now, how you all set your policies up is up to you. Ultimately, if anything goes south, the commission's going to go to the broker in charge. All right. So, Pat, you are the broker in charge for the sales department in Atlantic Beach. Okay. So again, it's going to be each office. The broker in charge of that office needs to make sure that this is being done properly. Okay. Now that they may not say you have to come talk to me every time we have a designated agency situation, but you need to be familiar with what your policies are as to, okay, if we're going to do designated agency, how do we proceed with this? Because if you end up in a designated agency situation that you shouldn't be in, and the commission ends up getting involved, not only are the brokers in the transaction going to be in trouble, but like everything else, the broker in charge is in trouble too, Pat. Yeah, Jim.
In that instance you just described, if I'm representing the buyer,
Right.
I am no longer a dual agent?
You individually are considered a designated agent, so you do not represent the seller in that transaction.
So
you represent exclusively.
Anything I know about the seller,
I'm getting to that.
Okay.
I'm getting to that. Yes.
It's my understanding, and correct me if I'm wrong,
Oh, I will.
haven't we always been in a designated agency situation when one agent in our company is working with the seller, the other agent is working for the buyer, the company is the dual agent. Therefore, we have already always been designated agents. We just haven't called ourselves that. Isn't
You
that
may have
correct?
been acting like designated agents, but you were dual agents and you were violating your fiduciary duties to the other client.
But wait a second.
Didn't like my answer, did you? That's, well, let me kind of say something, then let me say something and then you continue.
Well, we were
That's
dual agents.
okay, you go first.
I'm sorry. Go ahead.
Go ahead, Betty.
Go ahead, Betty.
We were dual agents, yes.
Right.
But we were also designated agents working, because we were working for separate parties. Isn't that
Not
correct?
if you didn't specify that in your agency agreements, and not if you did not have a policy authorizing designated agency. If you had no policy authorizing designated agency, and it was not spelled out in your listing agreements and your buyer agency agreements, then you were not designated agents. Now, you might have been acting like designated agents,
We were all.
but you shouldn't have been. You shouldn't have been, because you didn't have authorization to do that. And so and that's what I said, it goes against human nature. What we've all been doing is acting like designated agents when in reality we were dual agents. And we were, let me finish, and we were advising our clients and telling them I was the referee and I was going over to the bench telling the team on one side what the other team was doing.
But we have been being designated agents.
Exactly.
We have.
Exactly. So that's why I encourage my clients, do designated agency, because that's what all your agents are doing anyway.
That's right.
All right? And that's why, now here's something that throws a lot of people. Do you know when the Real Estate Commission said it's okay to do designated agency? Everybody thinks this is something new. Take a guess. I'll give somebody $1 if you can tell me.
In the very beginning of agency?
Not quite, but almost. 1997.
Okay.
It's been around for 17 years. Okay? It's like, come on, guys. This is what everybody's. It's like I said, how can I take off in the third quarter of the game? I've been out there busting my tail. These guys have been trying to kill me. And now I'm going to take off my uniform and put on the ref's uniform and be impartial? That's why a lot of people say this just goes against human nature. So that's what designated agency is. I get to stay on my team. So how you all have been engaging in your advising your clients and trying to get them, you're going to keep doing what you've been doing. We're just going to do it the right way.
We're just going to label it.
We're going to do it the right way. Because, and here's the problem, Betty, if you are acting as a dual agent, like I said, you have as much duty to, let's say you were working with a buyer, you have as much duty to the seller as you do to the buyer.
Right.
So if you gave that buyer any kind of information that gave them an advantage over that seller, you had breached your fiduciary duty to that seller.
Right.
And if the real estate commission found out and could prove that that happened, you'd be in trouble.
Well,
And
see,
we don't want anybody getting in trouble.
I just recently came back here from Virginia. I'm from here, but I went to Virginia. We did designated agency.
Right?
So when we came back here, you know, I thought,
Well,
why
the STAR team did
nobody's-
designated agencies.
We're not labeling ourselves designated agents here, and I, you know, so.
We did at the STAR team, Betty, that's what they do over there, but we don't, or hadn't, we will after this meeting, start doing it, but,
Over there, they don't even do dual agency.
well, they are, but they.
Well, and remember, it is dual agency. You can't do designated agency
Right,
without
gotcha.
dual agency.
That's right, I know.
So, your firm will be a dual agent. All of the other agents who aren't involved in that transaction will be dual agents. But the designated agents will represent that one client exclusively. Okay? Yes?
I've always acted as a dual agent, maybe because I got my license a little bit later than some of the people in here, and I've never been a designated agent. I always make sure both sides are aware, if the situation arises, I am a neutral party.
Right.
I cannot give you any information about them, I cannot tell you where to come in, I do it all the time, and I've never had an issue with
Right.
it. But I do have a question, because in my opinion, if you do a market analysis for a seller, things change over a few days sometimes, or a month, and you sort of keep them up to date with where the comps are, where the prices should be. I've always felt that for that buyer, even though you're a dual agent, you have the responsibility for them also to make them aware of comps. And you said earlier, you don't do a market analysis for somebody if you're a dual agent. If you're fair with one, you got to be fair with the
Well,
other.
and again, what you don't want to do though is if you've done a market analysis for the seller and you've set up a list price,
Right.
you don't want to go do a market analysis for the buyer that comes in lower than that list
But if
price,
you're
because
keeping
that,
the
let me
seller-
finish, because that's putting that seller at a disadvantage. So what you do is you say, I can show you comps, I can, this is the price, here are comparable sales, but I can't do anything as far as advising you on what you ought to offer for the
Well,
house.
I've never told anybody what to offer. or
Yeah.
anything. I've always been neutral, and I mean, we're
But if
all
I'm doing a
adults, it seems
CMA
like
for them, I'm
that's
giving them
easy.
advice on what to offer for the house, right?
What now?
I said if I do a CMA for that buyer,
Well, there's such a range in there, and I tell them, I said, you got to take into consideration of, the qualities this has and stuff, and do it for yourself. But I mean, most of the time, we price things pretty much within reason anyway, so it's like fair and fair. I mean, to me.
well, let me ask Pat, are you all gonna still do dual agency, or are we gonna try
We're not
to?
taking any of the agencies away, we're just offering designated agency when need to be, when it needs to be.
And my recommendation is, if you're gonna need to be giving a buyer that kind of advice, consider designated, because then there's no problem.
I've never had a problem, and I'd
You know.
say half of my sales, if not more, have always been doing, I've been doing.
Well, and
Everybody's different.
I would just be careful about actually
Well, I
doing
am.
a
I
written
am.
CMA
Well,
for a buyer
I
when we're
don't
in dual
always do a
agency.
written CMA, but
Yeah.
I'll show them some comps, we got this house sold here, that, like that.
That's fine, I mean, you can show, but you don't want to do anything that could be construed as, and I'm sorry, what's your name?
Teresa.
Teresa told me I should offer less than what that seller was asking.
No.
You don't want anybody to come back on you and be able to say that. Okay, yes?
Is it true when you declare your agency relationship with the seller that those listing files need to be under lock and key?
There's nothing that requires that. Let me proceed a little bit, because we'll talk about some of the requirements. Can we hold questions and for just, go ahead, that's
I was
okay.
just gonna say, if we are gonna practice as an agency, the firm is required to have a written policy stating that.
Yes.
And then
That's
we
what's on your
can
desk, right?
practice, do we have a written policy?
Yeah, it's right there in front of you.
Right here.
Okay.
Okay.
Before we start, let's go through, because I'm going to cover kind of the nuts and bolts, and then we'll do more of this Q&A stuff, which we need to do, but we're kind of getting ahead of where I am in this presentation. I think I'll answer a lot of these questions. So again, remember, designated agency is dual agency. It's a form of dual agency. All right, they're not exclusive of each other. All right, this is something these are some of the rules that we need to make sure we comply with. All right, the identity of the designated agents has to be disclosed to each party before you enter into a contract. All right, so you need to make sure you do that. The clients need to know who the other agent is. So that's one of the requirements. In order to have designated agency, going back to the example I gave, Jim cannot know any confidential information about Pat's seller. And vice versa. Pat cannot know any confidential information about Jim's buyer. Okay? If you know something, if the listing agent told you, gosh, I'm working with these sellers and it's a nightmare. They're going through a divorce. They hate each other's guts. They're in a child custody fight. I can't get them to agree on anything. You know, we got to get this household. They just want to get rid of it so that they don't have to fight about it anymore. We've got it listed for $275. Man, I just wish someone would come in with a lowball offer so we can get rid of this house. I'm sick of dealing with these people. All right? And the next day, my buyer client wants to go look at that house. That listing agent has just excluded me from being a designated agent in that transaction. Everybody understand where I'm at? Because that listing agent has given me information concerning price, terms, and motivations about that seller.
The seller authorizes you to say something like, we'll consider all offers.
Anytime a client authorizes you to disclose price, terms, or motivations, that's fine. Get it in writing. All right? People always, I don't know why, people always, when we talk about disclosure of anything, document it. Somehow document it. Whether it's a material facts or disclosure of confidential information or anything like that, you always want to be able to prove you did it. All right? People forget things. People, here's a hint. People lie. All right? Because what's your name?
Christie.
Christy, let's say I was the seller and I told Christy, yeah, go ahead and tell them. And then later I get mad at Christy, or I think the deal didn't go the way I wanted it to, and I get mad, and so I file a complaint with the Real Estate Commission. And I say, Christy went and told those people all this confidential information about me. And Christy says, oh, Gary told me I could tell them that. And I say, no, I didn't. She's lying. Where's your proof? So don't ever get yourself in that situation. All right, getting back to this. If you know confidential information, and this is critical, if you know confidential information about the other client, you cannot be a designated agent in that transaction. It's an automatic disqualifier. Okay? So that is should be, Pat, I believe that's in your policy. Keep that, and that's on you all, and you've got to be straight about that, because if you know something confidential and you keep going on as a designated agent, that could blow up in your face. All right?
You know, we're small down there. We're gonna run out of people.
Well, that's the other thing. If we're going to start doing designated agency, we got to start thinking about what we say in sales meetings and the gossip.
Caravans.
Everything.
Yeah, the gossip about the clients and what morons they are and how they're driving you crazy, and you know, we have to really get our mind wrapped around that hey, I don't talk about my clients anymore. I'll talk about the property all day long, but I can't be just blabbing about my clients and giving confidential information to the other agents in my office, because that is going to inhibit designated agency. Now, it's fine in straight dual agency, because I'm not going to share confidential information in dual agency, right? But in designated agency, it's a deal breaker.
I don't know how we could be designated agents the way we're set up right now. But we've always been dual and always shared for the benefit of the seller. All right, look, these people need to go ahead and they need to sell it really bad, see what you can do and stuff. And then I don't know how we can do it unless we completely
Well,
change
that's why
everything.
we're starting the training right now. Don't do that anymore. I mean, it's like I said, it's a change of your mindset. Now, the question about files, there's no requirement that files are locked up. All right, there's nothing in the commission's rules that says you have to lock up your files. my understanding with Pat is that we are going to change how we're doing our filing.
We're
All right.
dot loop, so.
When we go to electronic file keeping systems, and then you're only authorized to access files that you have a reason to be going into. All right? So as we get into this electronic age and as more and more firms go to designated agency, the days of unlocked file cabinets where all the files were in there and anybody could go pull a file and look at it, those days are over. All right? And that's another thing to consider. So not only do I need to be more careful about what I say, I need to keep my nose out of other people's files that I don't have a reason to be looking at. All right? I'm only going to be dealing with files that I am involved in those transactions. I'm not going to go grab some listing file that's not my listing and start looking through the file. If I need information about that property, I need to go through the channels. Okay? So, confidential information, that is really the most critical part of this. All right? Because like I said, if Jim knows confidential information about Pat's seller, he cannot be a designated agent for that buyer. All right? And if that buyer insisted on designated agency, then the broker in charge would have to appoint a different agent to represent that buyer. Jim would be out. All right? So I'm ticked off at that listing agent for blabbing to me about that couple getting a divorce because you just bumped me out of this transaction. Now, how you all will handle compensation in that kind of situation, that's something that the firm has to figure out. But Jim would not, if we were going to proceed with that transaction with designated agency, Jim would not be able to be the designated agent for that buyer.
I could be the dual agent. I could be
You could do
remain
dual agency.
and protect
But if the buyer says, no, I don't want dual agency, I want someone exclusively representing me, you're out of the deal. Okay? So that's something we all need to think about when we get into designated agency is chatter, idle gossip about clients. Got to stop doing that. Stay out of files that you don't have any reason to be looking in. All right?
Make it clear to our buyer and seller.
We got, folks, we can't all be talking at the same time, okay? 'Cause we're going to have a Q&A, so we'll have time to do that. Go ahead.
If we make it clear to our buyer and seller that we're practicing dual agency and I can't reveal anything to you and I can't reveal anything to the buyer or the seller, then we're safe to continue on with dual agency. We don't necessarily have to go into designated unless exclusive representation is desired.
Right.
Is
True.
that the whole
True,
that?
yes. You can offer dual agency and designated agency. Okay?
Do we have to offer?
You don't have to do one or you don't have to do any of it. We could decide today Bluewater is an exclusive buyer agency firm. We're not going to list properties anymore. We could do that today if that's what we wanted to do. Or we could flip that coin. We're not going to work with buyers anymore. We are an exclusively listing company. All we're going to do is list. Okay? But if we're going to list and sell, we want to be able to sell our own listings. So we have to do dual agency. Whether or not we take it a step further and do designated agency is totally optional. Nobody says you have to do it.
Depending on how you need to please your buyer or your seller.
Well, ultimately, it's what does the people in charge of the firm decide? How do they want to do it? But if they allow both, then yes, it depends on what does the client want. Okay? What is the best fit for that transaction? But I think what you're going to find is what Betty was talking about is in a lot of dual agency situations, people are acting like designated agents anyway. And they shouldn't be because they haven't jumped through the hoops. Okay? Let me get through this. I know a lot of people have, I'm sorry, I was going to, told you I'd call on you next.
It's important to also recognize the difference between what's confidential information and what's public information in your mind. You know,
Well,
for instance, if you know if someone is going through a bankruptcy, I mean, you know, that may be public knowledge. So I think it's just important to have a hands-on on which is which.
Yeah, but tread carefully. Because remember, price, terms, and motivation, right? So if my motivation is I'm going to go bankrupt or I'm broke, yeah, some of that may be public record. But if that's my client, I don't want to go telling people that.
Right.
All right. Now, well, again, just in general terms, anything to do with price, terms, or motivation of your client, confidential. As a fiduciary, it's confidential to you. All right. It may be a public record that somebody can go out and find if they go looking for it, but I'm not going to be going around telling people that. Okay. Yes.
In our MLS, we have actual boxes that bank owned, yes or no. So that's marked right in the MLS. So we can.
Yeah, that's fine. That's fine.
So not all bank owned, if it's bank owned, it's not gonna necessarily be on the MLS. It's
Well,
an
but,
optional field.
Well, we're talking about stuff about our clients. Okay, you can talk about the property, and if the property is bank owned, that's a material fact.
No personal information.
That's not personal. Okay. All right. So those are what you need to be thinking about as far as what's confidential. So there are specific motivations for being in the transaction, their willingness to either accept less if they're the seller or pay more if they're the buyer, and the terms that they're willing to agree to. All right. And then this is kind of the catch-all. If they specifically tell you something that they don't want you to share, even though it might not neatly fit into one of those categories, consider it confidential. Unless, of course, it's material facts, so you always disclose those. But that's talking things about them, about the client. Okay? So, I'm sorry, what was your name?
Cindy.
So if I have Cindy's seller and I said, told her I was going into bankruptcy, and I said, I don't want you telling anybody that. That just became, now there's no question, that's confidential. Okay? So these are kinds of things we've already talked about. This is going to take a little change in mindset, right, for some people. So we don't discuss our client's personal information in the office. So you got to kind of start thinking about, watch what I say. Talk about the property, don't talk about the client. Keep files secure, and we're making moves to do that. There's no reason why everybody should be able to access all the files. There's just no reason. All right? And things like common fax numbers, a general email address where multiple people have access to that. Don't have clients send you confidential stuff on those, what I refer to as community or common addresses. Okay? So you don't want somebody to fax something to you about like financial information, and it ends up on a pile of other faxes, and people are flipping through seeing that. All right?
Email, though, is available to our IT guy, every email that's sent.
Yeah, he looks,
Everything. He doesn't want to, he doesn't have time.
Well, then your IT guy can't be a designated agent.
Right, I'll talk Fred.
I'm sure Fred loves that.
No, I mean, that's it. The IT guy can't be a designated, is he a broker?
No.
Well, and it doesn't matter what the IT guy sees.
Okay, good.
All right.
Well, I think also if you consider the character of the agents in our office, if you were looking for something and there was 4 or 5 faxes there, you would be looking for what you were looking for. You wouldn't be trying to see what else is in there. It's
We're going to be
just
changing
character
the way
of
that the fax machine with this new phone system anyway, so that's gonna, we won't be having faxes for many reasons.
Well, what is your name?
Sandra.
Sandra, I would love to believe that, but I was an investigator. I was an investigator for the Real Estate Commission for 20 years, and I may love and completely completely trust every agent I have working for me, but I'm still gonna have those policies in place. You might see something you didn't intend to see. It's not that you're intentionally doing something wrong, but you might end up just seeing something you didn't intend to see. Once the genie's out of the bottle, you can't put them back in. So again, I am not, please don't think that I am trying to imply that I think we have a lack of character among the agents. I am always going for security, all right? I don't want anybody to, and I'd love to think we could trust everybody, and you're probably absolutely correct. I'm sure you are correct. But especially if I'm the broker in charge, if I'm the one ultimately on the hook, I'm not taking the chances. I've seen many, many, many brokers in charge get burned. And I wish I had $1 for every time a broker in charge said, I can't believe that person, and fill in the blank. All right?
Is it not true documents were all created to protect the public? Because I know back in the 60s, when my mother had real estate transactions, a lot of agents weren't even, there was no such thing as brokerage. I think it was mid-60s when they came out saying you had to have a license
In North Carolina, it was 57.
Right. My mother had a person that represented her in a transaction in 67. 2 years later, she called my mother up and said, "You still owe me some money."
What happened 50 years ago,
Yeah,
I mean,
but I'm saying it all came
there was,
right down to agency. My mom thought she was represented, but she really truly wasn't. So a lot of these documents, when I got into real estate in '84, were created to protect the public from crooks in our industry.
well, I will tell you that everything the Real Estate Commission does, their reason for existence is to protect the public. That is their mission statement.
Right.
To protect the public in real estate transactions. So absolutely, this is to protect the public.
Right. Not saying that none of
Okay.
us are, have less integrity. It's just that among us all, no matter what industry we're in, we're always going to have somebody that's going to.
Well, and with agency, it's so critical because it defines what is our relationship with this consumer. All right, and they need to know what is my relationship with this person, because this is the biggest investment I'm ever going to make, and I'm relying on you. And I don't want to tell you something in confidence and then you turn around and it ends up getting used against me, right? So, or hey, if you're my coach, and now all of a sudden we're into the game, and you tell me I'm not your coach anymore, I'm floundering. It's like, I need you. So that yes, it is to protect the consumer. Absolutely is. All right. Not that we're all out to stick it to the consumers, but that's the whole reason we have all this. But yeah, I mean, it is critical that we explain this, make sure they understand what the relationship is, and give them the relationship that they need. Okay? Nobody says you have to do designated agency in every transaction. As long as the firm says, hey, you can do traditional dual agency or you can do designated agency. All right? It's just another option out there. But again, designated agency, we got to follow these particular steps. And the biggest thing of all, we can't be just running around sharing confidential information about our clients, or we're eliminating that as an option. Okay? Just a couple of more things and then we'll do more talking. The commission requires a written policy, which you have, specifies how these people get appointed. All right? So you'll need to review that within your firm, what the policies are. Now, I believe, Pat, correct me if I'm wrong, I did read yours, that the buyer agent and the listing agent will automatically be considered the designated agents unless they know confidential information about the other party. Is that pretty much it? So they're not going to actually have to come to you every time and say, I need your blessing to do designated agency. Is that correct? All right, you all will be discussing that in more detail later. Okay? But the policy has to specify how that's going to be done. It doesn't have to be one person. So if Pat and Jim were both on teams, all right? And nobody on either team knew confidential information about the other client, we could appoint each team to be designated agents. So it doesn't have to be just one person. So I don't know how you're going to handle that, but that's an option as well. You can appoint multiple brokers to be a designated agent for the buyer and multiple brokers to be the designated agents for the seller.
We don't really have teams, so.
Okay, well,
If we did. then-
it's an option that's out there. Okay, it doesn't have to be a team. It just might be, you know, Jim was working with somebody helping him on that deal.
Yeah.
It's like, okay, you two are representing the buyer. All right, it's an option. All right, another restriction. The example I gave wouldn't work because Jim is a provisional broker. I know that because he's one of my students. He just got licensed. Jim's a provisional broker and Pat's his broker in charge. All right? They are not allowed to be designated agents in the same transaction because Pat's got to supervise Jim. And if they can't discuss confidential information about the clients, how is Pat going to adequately supervise Jim? Okay? So Pat can be a designated agent, Jim can be a designated agent, just not in the same deal. Okay? So keep that in mind. If you're provisional, if the listing agent's your BIC, you can't be a designated agent in that transaction, or vice versa. If you're the BIC and you're working with a buyer and the listing agent's a provisional broker, you couldn't be a designated agent in that transaction. Okay? All right. So let's go. Have at it. A couple of people. Who did I miss? You've been waiting, and then I'll get to you.
The designated agency, if, I represent both on one listing, am I required to offer designated agency?
You can't be. There can't be one designated agent.
No, I know that, but am I required to say if I'm representing the buyer and they like one of my listings?
Right.
So if I don't, and I explain dual agency and I say this is how it works and they're fine with that, but could they come back later and say, you never offered me designated agency, I would have preferred that, and that come back and
No, it's in the bottom.
Well, here's what we're going to do. Here's what we're going to. Once the firm pulls the trigger on designated agency, you're going to have that discussion with them when you enter into your agency agreements. So you shouldn't have somebody coming back later and saying you never offered that to
So we
me.
will always offer it from
That
here on
is up to your firm. All right.
Yeah, after.
So if
Now,
I'm
if you don't-
inside the transaction
agreement anyways.
Okay. So.
people sign those things that really.
And
And you
you
explain it, they
you'll
don't
explain
remember.
designated.
They don't remember.
Okay, well, here's the deal, folks. We're gonna review, we're gonna go through the agency contracts with the clients, and discuss this with them and what the options are. Okay? Now, in your situation where you're the only agent involved, and they say, well, I want designated agency, you say, well, at this point, I'm the only agent, so I can't exclusively represent you. If they say, well, I want exclusive representation, then that's something that the broker in charge is going to have to step in and appoint another agent.
So I go to Woody and say, my buyer wants representation.
Yep,
Finding an agent.
yep, I need somebody else to represent the buyer.
Do they get paid?
That's up to the firm.
We had talked about, and Woody's not here, we had talked about referring, like if she had a buyer and then they wanted specific representation to refer it to you, and then you would just pay a referral since she's handing you that buyer. That makes sense. I mean, is that not fair to everybody?
Say it again, Pat.
If she has a buyer and they want specific representation, they will not enter in the dual agency, and she gives it to you, you would just owe her a referral back. I mean, I feel like that's fair. She's handing you a
So if I
buyer.
gave it to you, I said, Marsha needs a representative for this buyer, or Woody says, Marsha wants you to.
She was the listing
agent.
agent.
Referral
She was
back.
the listing agent if I heard
But
her
you
right.
get.
Let's not have two discussions.
Yeah, guys, let's keep, we can't have multiple people talking at the same time or nobody can hear. So I'm gonna take over. All right, so your situation, and Pat, correct me if I'm wrong, and I don't know people's names, so excuse me for pointing, but, okay, so you've got a listing, you're working with a buyer wants to buy your listing, they want exclusive representation. You decide, I'm gonna stick with the seller, so I need Pat needs to appoint somebody to represent the buyer. So as I hear it from Pat, Pat appoints you to represent the buyer, says, do you want to represent the buyer in this transaction? And then you get a referral fee. Is that right?
After we get a
I would get a
referral.
referral, she would get a
Because you're-
commission.
Oh, she's gonna get the
But she's
commission,
gonna
but she's
work
gonna
it.
pay you back a referral fee.
Correct.
That works.
Does that not sound fair to everybody?
I
I mean,
mean,
that's
it
not
does.
set in stone, but I mean, that's what
It
other
does, because I'm
companies are
already
doing.
getting the listing side of the commission, so,
But you have
and
to
you're
sell
gonna
it.
work
You
hard
have
to do
sell
that.
it. Well, see, you have the buyer and the seller.
All right, you know what, folks? This is gonna have to be a discussion for a later day because this has nothing to do with that. How we get
This is
paid
firm policy.
is a
Right.
firm policy. It has nothing to do with the law. So you all, that's something you all are gonna have to discuss internally and figure out. But the point is, if that buyer says, I want exclusive representation, someone's gonna have to step in.
But if he doesn't, we go on like ours.
Correct.
If they say we're fine with dual agency, then you're a dual agent, and you have to be the referee,
Okay.
okay?
It really keeps us from having to say, if we were to have a customer without this policy and they came in and said, we want designation, we want to, well, oftentimes they just go off and find another buyer agent from another company. So that keeps us really from losing them because we can send them over to another agent within our
Well,
company.
again, you don't have to do designated agency, and if you are the only agent in the transaction, and everybody's fine with traditional dual agency, be a dual agent. But again, remember, when you're a dual agent, you're the ref. You cannot be given advice to either party that's gonna give them an advantage.
So since we know that our firm is gonna start designated agency, we need to keep our mouths shut about any listing that we've got, because we don't know, we might have a listing, if we divulge everything, Betty might come up and say,
Right.
oh, I'm gonna be designated agency, and spill her guts about everything we've told her.
You
Right.
do not,
So,
you
keep
can't,
it all
don't
confidential.
discuss confidential information about your clients with the other agents in your firm.
You can't
That's mainly
succeed
during
if you're
caravan
waiting
as well.
on
I can, but she's being very patient and then other people are jumping in, so go ahead.
Well, I was gonna ask, I have had listings where the seller has said, you specifically, Cindy, I do not want you representing any buyers.
Okay.
Okay, so in that situation, kind of follows along with what Kathy was saying. Let's just say I start working with a buyer, and he wants to look at that particular listing. At that point, I've already been working with the buyer, so I've gained some knowledge and probably confidential information about him.
Mhm.
How do we handle that? If he wants to say, I want to see this listing, at that point, my seller has said, Cindy, I do not want you representing any buyers, yet I've already got what?
Well, and that's really an excellent point, and it does go back to what you said. It's gonna be really hard when we talk about appointing someone else. How much information do you have about that buyer? Because I think if we're at that point where they're ready to submit an offer, you probably do have confidential information about that buyer, correct?
Yeah.
And in that situation, you can't be a designated agent. So this whole discussion we just had about somebody else has to work with the buyer and how we're gonna handle the compensation, that's gonna be really hard to do.
So do we tell our buyers, don't tell them anything?
No, you're gonna say, if you're gonna look at my listings, I can only be a dual agent.
That's right, that's
Right,
right.
you have
It
to go
comes
back
down
to
to the
the
seller
lawyer.
in that case, I think. The seller needs to be aware.
Well,
So
you
if you're-
can't be a dual agent if the seller's told you he doesn't want you. If he does not, if he only wants designated agents. But
That's something, if the seller says, I only want designated agency, I will not do dual agency, I want designated agency, all right? Then you really can't,
You have to send another
if you
file.
send your buyers to look at that house, you're almost excluding yourself from the transaction, because how am I gonna, if I have confidential information about the buyer, I can't be a designated agent for that seller.
That's a disadvantage to our sellers to do that.
Yeah, why would the seller?
Well, can they call, could you call the seller and just say, I've got a buyer that wants to look at your house, but it's my buyer?
Well, guys, you're gonna occasionally run into this, and actually, I'm not gonna, I don't know who the person was, or you may know, but Woody called me a while back about someone who wanted to list the property and said they would not do dual agency. They absolutely refused dual agency.
That was my seller, and he
was
was
it?
an attorney in another office, sold it, so.
Well, but when he called me, he's like, what, I said, well, you could explain to him that if you will not do dual agency, that none of the agents working with buyers in your office are gonna be able to show that house.
That's right.
And the seller didn't care, right?
Right.
He was an attorney.
So, but I mean, it's kind of similar. If you tell people, you know, if you want exclusive seller representation, then, you know, and if you have a buyer agency relationship with someone, you really can't do designated agency in that situation. You can't represent both parties and then at some point try to separate that because you're going to have confidential information. So I am backpedaling a little bit. I mean, technically, if you had no confidential information about that buyer, you could let another agent step in, but I don't know how that would ever happen.
We have
But
the
once you're no
attorneys
longer
anyway.
representing that buyer, that confidential, well, I don't know.
No, once you know it, it's like, you know, the term I use, once that genie's out of the bottle, you can't put him back in. So once, if that buyer had given you confidential information, which in all likelihood they have,
What you do is you explain to them, I want you to know, if you go over here, I know confidential information that I can, just, that I am under.
well, see how that flies.
Yeah.
I have a friend that has a firm, and she says they only do seller to seller sub-agency. They will not. So if a buyer wants to buy something, they tell them, I'm representing the seller, but I'll be glad to.
And again,
Would that work?
Century 21 Waterworks.
it is all, well, you would never have buyer agency agreements, and a lot of buyers in that situation are gonna go to another firm and get a buyer agent. If you say we only offer seller sub-agency to buyers, so I don't represent you and anything you say can and will be used against you, bye.
Yeah. She said it works well for them, but I don't.
They're not disclosing.
Well, it sounds like we just have to be upfront with the seller and convince the seller is to their benefit that they do allow us to represent them as a dual agent. Because, you know,
It's all educating the consumer, folks.
Exactly.
All
I
right?
think it's how you approach your sellers. If you built that rapport with them, you know, and they trust you and you explain it right, they see the character behind it, they'll go along with dual agencies.
Well, but you will come across sellers who are gonna say, I want exclusive seller representation, I do not want to do dual agency. And if that's what they want, I don't know how there's any way you're gonna be able to show buyers that you. So you're gonna get 2 referrals now. Before we stampede the herd, guys, that's probably not gonna be a very common problem.
exactly.
All right, so let's not get bent out of shape about something that's probably not going to happen very often, if at all. All right, we explain what the options are on the front end. I have buyers I would like to show your house. If I find the buyer, and as opposed to another agent in the firm, and I'm the only agent, then I have to do dual agency, and I'm still going to be fair, and I'm still going to help you to the extent I can, but I won't be able to advise you in as much detail because I will not be able to do anything that would put my buyer client at a disadvantage, because I'm going to be representing both clients. But I'm still going to work with you, and everything's going to go smoothly, and it'll all be wonderful, and we'll sell your house. Okay?
In as much detail. You say in as much detail, you won't be able to help them in as much, with as much
I
detail.
can't give them any information that would put the other client at a disadvantage. So, to the seller, if I know the buyer is willing to pay more than their original offer, I can't go tell the seller that. Here's their first offer, but they're willing to pay $10,000 more if you don't like it. All right? I mean, it sounds silly, but that's just an example. I can't share information about either party that gives one party an advantage over the other. I'm the referee.
But that's basically limited to price, terms, and motivation, basically, right?
Price, terms, motivation, or anything that they said is they want kept confidential, other than material facts are always disclosed. Go ahead.
and I know I was late, but I was on Woody business.
Oh,
So
that's okay.
I just wanted to ask you, okay, now, we got this thing down about how we explained dual agency and all that stuff to people, which was awkward as it could be. There was a lady that came in the 80s and she scared us all to death, Barb or somebody.
Yeah, I remember.
And so now, just pretend you're just meeting someone, you're a realtor. You're meeting someone, hi, how are you? They're walking. Give me just a brief thing, and if you did this earlier when I was late, then I was going to do it. But what do you say? You covered your designated van?
All right, what is the first thing we do?
Working with a real estate
Make
agent.
sure they're not working with another
Well, I
agent.
asked
Are you already working with agents?
And folks, since this came up, and this is something I want to share with you, the working with real estate agents brochure is not optional, and it's not an afterthought, and it's not something that the Real Estate Commission doesn't care about. All right, the first thing you need to do is go through that brochure. That starts the conversation and the educational process.
when they walked in on the street.
When you, before you, the rule says first substantial contact. Now, in this day and age, what is first substantial contact? It can be all over the place, you know. Now it's not uncommon that people go through an entire transaction and never are in the same room with their client. They don't even know what they look like. All right? Before they share any of this confidential information, that is what the commission defines as the absolute final straw. Before you have any discussion about price, terms, or motivation, you need to have gone through that brochure with them and get them to sign it. I just did a compliance audit last week, and out of 6 files, 2 of them had brochure panels that were signed after the buyer agency agreements. They signed the panels the same days they submitted the offers. I'm like, you got this backwards, guys.
Well,
That's
sometimes you speak to them and don't get them to sign it. You explain it to them without signing the brochure. You're saying you need to sign it.
If they don't sign it, then you write on the panel that they didn't want to sign it. But you need to document that that was the first thing you did. The commission disciplines people for this. They look at it very seriously. All right? Because they want the consumers to understand what is my relationship with this broker before they start blabbing everything. All right?
Then what do you do?
Then, if they want to enter into an agency agreement, that's where you've already gone through the brochure with them, so they have a basic understanding of what these different types of relationships are. And then when you go through the listing agreement or the buyer agency agreement, you say, okay, here are our options. How would you like to do this? This is how this will work. You tell me what you want. Okay? And that's where, if you're dealing with a seller, that you say, I will not be able to show my buyer clients your property if you refuse to have dual agency. The other agents in my office will, and we can do designated, but if you say I want exclusive seller representation, I can't be your exclusive seller representative with buyers that I'm working with. I can't do that.
Generally, they want you to sell the house, so they want you to.
Most of them aren't going to have an issue with it. Are you going to occasionally have somebody who wants to do it their way? And you know what? Again, you got to kind of run this through your office policy, but there's no law that says I have to always take every potential client.
Exactly.
You know, if I just don't want to do that, and I tell my BIC, hey, I don't want to do this. If this person won't do dual agency, I don't want to take the listing. And the BIC says, fine, don't take the listing. Then, sorry, I can't do that.
It's probably overpriced anyways.
It wouldn't have sold anyhow, right?
You
You're
don't
probably
have to.
listing a can of worms if you got somebody like that. Something's gonna come back and bite you in the end.
Might. It might.
Hopefully another agent.
Okay, let's go on this side room.
I know I'm crazy, but I'd like to hear you explain, like how you would explain to a client working with real estate agents and doing your brochure.
Of the brochure?
Of the brochure, I want to hear
your words explaining it.
I am going to read the brochure. I'm going to go through the brochure and read it to them and explain how it works. I don't have a brochure in front of me. This is something that you all handle in training sessions, but you just need to go review it with them, read it to them. I mean, if that's what it takes, ask them, do they understand? You know, this is what this is what agency is. This is how it works, and it's just explain how it works. You know, both. This is dual agency. We work with buyers. We work with sellers. If both clients are within our firm, this is going to be a dual agency situation. Use my referee analogy, if that helps.
So that's what I was curious.
Yeah. Use the referee analogy. You know, if I become a dual agent, I'm not going to do anything that's going to hurt you, but I can't do anything that's going to hurt the other client either. I have to be neutral. So there are some things I'll be able to help you with, but other things I'm not going to be able to give you the same level of advice that I can if I represent you exclusively.
Now, that's the same with a guy you've worked with 4, 5, 6 times. You don't go, that's it. You know. They usually say, look, I'm fine.
Oh, yeah, I mean, yeah, if it's someone you've dealt, who's been through the, been to the rodeo before, yeah, you're not going to go through the same level of explanation every time. They say, oh, I've read that thing a million times, I know all that, let me just sign it, let's get going. Okay, fine. All right? And again, if they refuse to sign it, just write on there that they didn't want to sign it, throw it in the file, keep on trucking. Keep going.
I was just gonna say, when I explain dual agency, all I say is, all I am is a mediator. I'm gonna hear your side, their side, and we're gonna put the deal together. But I can't help anybody. All I'm there to do is help get that.
Well, I would say I'm helping everybody. I'm not helping anybody. I would put a positive spin on it. But I can't. Right. I'm working with both of you. I'm representing everybody fairly and honestly, but I can't represent one person's position over the other person's position. So I will be representing both of you, but I have to remain neutral. Okay?
I have another question. If I've had a listing that's expired.
You're next.
If I've had a listing that's expired, do I still have some kind of duty to that?
No.
Okay, so my new buyer, I can tell them anything I want to tell them about that listing.
Once your agency agreement expires, your fiduciary duty is over. So if I have confidential information about a former client that I no longer have a relationship with, I can share that now with my new client. So your example, I had a listing. My listing expires. Now I'm working with a buyer. That agent has listed with another firm. Now, if it's another Bluewater office, right?
Yeah.
But they go and they list with Emerald Owl Realty. All right. So now they are represented by someone else. I'm representing this buyer now. If I keep this in mind, if I have knowledge of the price, terms, and motivations of the other party in a transaction, I have to disclose that to my client. Okay? So in your situation, now I'm working with a buyer, the listing's over at this other firm now. Hey, I had that listing before. That seller's getting divorced, he's moving, they gotta sell this house fast. They've already dropped the price from what I had it listed at, and you can make a lowball offer on this house, they need to sell now. All right? Now, people go, well, that's not ethical, that's not. What do you mean? They know who you are. They know what they told you. If they feel like it's putting them at some kind of a disadvantage, they don't have to accept the offer. No, they're just going to be happy you're coming in with an offer. Let's get some negotiations going here and sell this house.
They should have renewed my listing.
Pardon me?
Or they should have renewed their listing.
Yeah, you should have renewed it. So yeah, that's fine. That's no problem.
Okay.
Now, things like their financial information, their personal information that you have documents of, obviously that stays secure. Okay? But the things you know about that person, that's fair game. Okay.
Well, you just answered my question, because that's what I was going to ask. Does, when the The confidentiality ends when the relationship, when the agency relationship ends, if it's with another company, but not if it's within our own company. Correct?
Well, yes, because remember, it's not about you, it's with the firm.
Right.
The agency agreements are with the firm.
So
And then we are all sub-agents. So if a seller decides, for whatever reason, they're not happy with you, that would never happen, obviously, but just try to pretend that might happen. And then that seller says, you know, I still want to list with Bluewater, but this ain't working out. And my friend told me that Cindy was the awesome real estate broker, so I want to try working with her for a while.
But I'm thinking about that in the buyer agency standpoint, like Cindy's customer, when she had both of them and one had to leave and go to another agent within the same company because they wanted designated representation. That confidentiality, you cannot disclose them, even though that relationship has ended, that agency relationship has ended.
Well, again, the agency relationship is all in-house.
Okay.
So just because the brokers within the firm change,
Right.
the agency relationship has not changed.
Right.
The firm represents the client, and all of the agents are sub-agents of the firm, so all of the agents represent all of the clients. So the duty remains the same.
Judy, you had a question, didn't you? Or have you forgotten it?
I've had 20 questions, and now I'm writing them down.
Go for it. I'm sorry, there's some aggressive people in here.
I think my biggest question is, I've been with Bluewater for 21 years.
Okay.
And we've had the same question twice. And we have talked about it, right, just pulled it apart and whatever. And both times, the powers to be decided no. So I'd like to know now why. Is there something pushing us now? Is it legal that we're now talking about it?
I can't answer that question.
I mean, I think it's obvious that, from what somebody said earlier, that we possibly lost some business because we didn't have a designated agency. That's what makes sense.
Yeah.
That's all, I think that's why we're doing this today.
It's
Well-
a service that we are going to offer that we haven't in the
They
past.
heard it at a seminar or something.
It's a good thing we have talked about it, because I think a lot of us didn't understand our obligations to our clients and keeping, and being the referee.
Also,
Right.
with
Only
Blue,
in
we're
Julia.
able to do this, whereas we weren't in the past because we didn't have locked files like, well, they were locked, but people had access to them and so forth, and it's
I
secure
don't
now.
remember
with-
why the last time, I think Cindy was broken when we discussed it, but it was decided by the powers that no, we're not gonna go forward with this.
Well, some people don't feel comfortable being a dual agent. I've heard several agents say they didn't really feel comfortable. Maybe that's why we're doing it. I feel comfortable.
But the good news is we'll be able to do both.
Right. I mean, we're not taking anything away, it's just we're adding to the service. But everybody does need to keep their mouth shut.
People,
in case-
people from different areas, and I think it's more normally people from up in the northern part of the country have a tendency to feel like they need to have designated agency. Maybe that's the people, because they're raised different than we are. I mean, we're all.
I think the
A
way-
lot of people are pessimistic. A lot of people feel like they're out to get it, and maybe that's why we're offering to do it.
In my opinion,
Down in the north, I look at it like they're not naive.
I feel like we'll go away eventually anyway.
Well, again, it is dual, designated agency is dual agency.
Well, in general.
Right. But I don't think it'll ever just go away, because you're always gonna have the situations where the one broker is representing both parties. And both parties are fine with that, and they like the agent's doing a good job. So that has to be dual agency. So I don't think you're ever gonna just do away with dual agency. My personal opinion is that designated agency, when you can do it, is a great way to go because of the situations Betty talked about. You know, it's just human nature. I'm on a team. I like this person. I want to get him a good deal. I like working with buyers, and I want to get this buyer a great deal. Because then they're going to go tell everybody what a great agent I am and what a great deal I got for them, right? I don't want to have to play 3 quarters for Carolina and then peel off the uniform and be a referee. That's no fun. I want to be in the game. So that's just my personal opinion.
Just one
All right.
quick thing, you're with the real estate commission.
Used to be.
Used to be.
Do they,
Used
first
to
of all,
be.
do they record the calls that come in?
Well, there's been a lot of changes since I left 4 years ago. I don't believe they actually record the calls, but they keep logs of all of the calls that come in, and it records the phone numbers. And so they do have a record of everybody that calls and what the discussion was about.
I have needed them I have needed them.
Yeah, I don't believe that they actually
I just
record everything.
But I have to say, the two people I talk to, they're always a tremendous help. I mean, it's just like, I just sort of say, and they're really good.
Well, and it's, I always encourage people when you have questions to call the real estate commission. Make sure you write down who you talked to and what they said. A lot of the people at the real estate commission really know their stuff, but you have some up there that don't know what they're doing.
Oh, really?
And so occasionally people will get just wrong information.
That happens
But
everywhere,
if you
doesn't it?
write it down and say, this is who I talked to and this is what they said, and then they can go back and
Right.
verify the phone call, if you did something wrong because someone at the real estate commission told you that was what you should do, then at least, you're protected.
Yeah, the case numbers too, you need to keep, they give you a case number.
Yeah,
and then
tracking
there's-
number.
Yeah.
Thank you.
So yeah, I mean, if they get see, they didn't do that when I was there. Actually, back at my time in the legal department, we had a piece of paper that we kept a log. And we just put the time the call came in and who we talked to, and it's like a sentence about what they said. They do all that electronically now.
Just call something different too.
Thanks.
Yeah.
They won't put anything in writing. If you email me what you just told me.
Not unless you submit it in writing. Yeah, if you ever want anything from the real estate commission in writing, you need to submit your question in writing. They won't just respond to a phone call with a written response because there's no documentation about what the question was. Okay. People have a tendency to hear what they want to hear. And, I hear that all the time where people will say, well, so-and-so at the real estate commission told me blah, blah, blah. And I go, I know that person, and I guarantee you there's no way that's what they said. They told me I didn't have to disclose material facts. No, they didn't. No, they didn't. That's what you heard. That's not what they said. Okay?
Well,
But
this is exciting. Dual agent, designated agency can be fun. I like the idea.
it's just, think about it this way,
Some of us
folks.
have listings that are listed
Hey.
to us. This is good.
Think about it this way. It's another tool in the toolbox.
That's right.
If I need to pull that tool out because I need to use that tool, then there it is. If I don't need it, it stays in the box.
Guys, can I say something? I mean, Woody and I have consistently for almost 30 years tried to make every cutting edge technology available to people. I remember when computers came in and Marcia said, I don't know if I can do this. But, being number one in the county doesn't just happen. I mean, so to be able to have every tool, like Gary said, that's in the toolbox, available to us is something we all need to try to strive to do.
Sounds good.
Can I ask one more question?
I got nowhere to go.
A lot of us here, I think, have got our own properties that we've listed at one time or other. Bluewater has, of course, have their own properties listed. Does that affect any of this when it's a company or agent-owned property?
If it is an agent, you are just another customer or client of the firm. Again, you'd have to look at that confidential information. So it could, yes, because it may be that all the agents know your particular situation just because they all know you.
Mm-hmm.
But if they had confidential information about you, they wouldn't really be able to be a designated agent for a seller of your property, or for a buyer, if you're selling your property. I suppose you could waive that and say that's okay.
Yeah.
But according to the rule, it says if I'm the other agent and I know confidential information about you as the seller, I can't be a designated agent for my buyer in buying your house. So
Well,
it
I think
could,
I think I saw something that I can't be a dual agent on my own property now. Isn't that right?
well, yeah, you can't be a dual agent. How am I going
Which
to
is
represent,
unreasonable.
how am I going to equally represent a buyer when they're buying my house?
What if I have my house listed and Allison sells it and we enter into dual agency?
Yes.
Okay, good, 'cause we did.
If you as individuals list your property with the firm doesn't, you're a client, okay? Now that potentially is going to affect the agency relationship with the buyer-client. All of this is going to be disclosed. I think it might make designated agency very difficult, but I don't think it makes it impossible. It depends on what the other, I mean, you and I may work together, but I don't really know you, you know?
Okay, so if we list our own property, my husband builds, he buys lots, builds houses on them, and I list them. Yeah, somebody was saying that they had took an update course, and after we were talking, I didn't even hear this come into play, so Christy must have said something. But somebody had said if somehow somebody in your family has owned that property or something, that you can't represent any buyer even as a dual agent. That's not right, is it?
Well, it depends on what the relationship is. You got a lot of disclosure issues. So your husband's listing the property with Bluewater?
Yes.
Okay. And what is his company?
It's a corporation, First Choice
Okay, so
Properties.
it's a separate
It's a separate,
entity.
it's an entity.
He's also
yes.
an
All right.
agent with Bluewater.
But, pardon me?
He is also an agent with Bluewater.
Well, he's an
He's
agent
also
with
an agent.
Bluewater, so yeah, you've got, all that needs to be disclosed. Now,
Well,
can
it's always
Bluewater,
disclosed, yes.
can Bluewater be can they be a designated agent?
No, I want to be a dual agent. I've always been a dual agent. I mean, everybody knows that these are his houses, he builds them, everything's up front, laid on the table.
Mandatory buyer agency.
I know, but I'm asking him because he's.
I'm thinking you are putting yourself in a potentially vulnerable position because you have, even though it's your husband's corporation,
And everything's laid out.
you kind of have an interest in that transaction. You have an indirect, you have an indirect, and you can say, I'm not a shareholder, I don't have any, you all go to the same house every night.
That's right.
And hopefully everything there is happy and comfortable, all right? So you can't just separate that. So you have an interest in that transaction, indirect, but you do.
But
So,
I never push anybody. See, that's the thing. I've always sort of, if anything.
please let me finish, okay? You have an indirect interest in that transaction.
At some point in time, if I ever get the opportunity to get it fixed up, I can still list that. Would it be the same thing even though it is our personal home? Could I be a dual agent?
Not if you're selling your own property.
So it has to be a designated buyer's agency that has that. So if I get somebody that might want to see my own personal home, they have to use another agent. Is that
No,
right?
you could be a sub-agent to the seller, you just wouldn't represent them.
Unless they want, buyer wouldn't have representation.
You know what?
Okay.
We're kind of getting on another subject, and this is a new rule, so I am not going to commit. I would have to review that rule before I'm going to commit to an answer.
Yeah.
All right? Because the new rule deals with you can't be a dual agent when you're selling your own property. So, and I don't see any way you can list your own property and any buyer within the firm comes in, that's got to be a dual agency situation, right? So the rule may say you can't be the listing agent in that situation.
Of your own.
How would I find out about that?
I will review the rule, okay?
We'll get back.
Because the rule says you can't be a dual agent when you're selling your own property. And so if you're the listing agent,
Sub-agent, you say sub-agent, could you be
you could
sub-agent?
you can still list it, but someone else is going to have to be the listing
Unless you're
agent.
sub-agent to the seller. Well, I guess
Well,
if
you just couldn't do dual agency.
Just dual agency.
You can't do dual agency. So, and designated agency is a form of dual agency. I'll have to read the rule. I want to cut this off because I don't want to speculate because I don't know what the rule says. I'm not familiar, I've read it like twice, so I would want to go back and review the rule before I'm going to commit to any answer, and speculating on it right now, it's just not, there's no point. Okay? Jim, hold on a second, go ahead.
Mine's kinda like that. I'm actually listing property for Bluewater as the owner's wife. And then my son is the builder, my stepson is the builder. And then if I bring in a client that's the buyer, we've always wondered how, I mean, we've tried to be very open and disclose and, you know, we're all related and so how's the best way to handle that?
You know, I almost have to dissect each of these situations separately when you start talking about it. So, Bluewater is the corporation,
Right.
correct? And
I
that is
list for
and
them.
that's the real estate broker. And then, who is the builder?
Bluewater Builders.
Is
which
that a separate corporation?
Yes.
Yeah.
Yes. See,
But
that's
owned
the
by
thing.
the same people.
Doesn't matter.
Okay.
Okay? We have separate corporations, so Bluewater Builders is just like it's another person who's listing with Bluewater Real Estate. Okay?
Jerry, when you research a little bit, I'm sure Woody and I are going to be calling you talking about this specific thing because it is awkward.
Yeah, there's nothing wrong with, I mean, the money can go in the firm's trust account with other people's money. It's a separate client, all right? So even though there's the common thread of who the people are,
Right.
the agency relationships and the disclosures and how you handle the money and all that is the same thing. Okay? And as long as it's disclosed to buyers and they say, we want, you know, Bluewater is going to act as a dual agent for Bluewater Builders and a buyer, and everything's disclosed, I don't see any problems.
But you have to disclose that the listing agent is related to that builder, correct?
Yes. That this is this is
yeah.
Bluewater Builders. This is our building company. All right.
But the actual owner of the property is Bluewater Associates.
Again, as long as all the relationships are disclosed.
Right. And
When you say the owner of the prop, who is the listing agreement with?
Bluewater Associates,
Okay.
which is Woody and Charles.
Okay. So as long as that's all disclosed, that, you know, here are the relationships of these different companies, you know, most buyers are not going to care.
Honesty is always the best policy.
Well, again, it's all just about disclosure. What they're concerned about is somebody coming back, and I'm sorry, I don't know your...
Sandy.
You know, Sandy was listing this property, and I had no idea that she was married to Cheryl, and he was the builder. I didn't know there was a relationship between these two. How could she possibly be fair in this transaction? She's obviously trying to work for his benefit, right? Disclosure, disclosure, disclosure. So as long as you're taking care of that, you should be fine.
But I don't have to on the listing, because I'm not a board member or anything of the company. I don't have to list that as, you know, like, if we own property together and I list something, I'll state that, you know, that I'm a real estate broker and I'm the owner of the property.
Well, again, what the commission requires is that if you have an interest in the transaction, which you kind of do, that you disclose that interest.
Okay.
So just...
But not on the listing.
No, it's just a matter of disclosing what was your relationship with these sellers. All right? And I think somebody should have a pretty good clue when everything says Bluewater on it. You know? So I think you're already off to a good start if somebody said, I didn't know. But again, just what the rules require is that if you have an interest in that transaction, that's a material fact, which makes complete sense.
Yeah.
Right? And so as long as the disclosures are being handled, it shouldn't be an issue.
Why can't an attorney draw up something stating what he is, what she is, and what her son or so forth, and have it as a disclosure for them?
I don't even think an attorney needs to do that.
Well, it really never comes, it's never been an issue so far, but, you know, there's always that, you know, we start talking about it, well, Bluewater owns the property, I'm listing it, I'm his wife, he owns Bluewater, his son is the builder, I mean, you know, so we always make sure that whoever's buying something is real clear on who we are and how we're all related.
And that's all you can do, and that's fine.
And then
And then if they choose at that point they want somebody else to represent them, say they're the buyer, then we would have to go to the designated agency, correct?
And make sure that there's, written agreements between the different entities.
Right.
And that you've got all that, because even though we're all in the same boat, legally, we're separate legal entities, so there's got to be written agreements.
Is that what you were gonna say?
Exactly. So we disclose, we decide, and we document.
That's always a good way to go.
Disclose.
Disclosure is always the key. Document what you disclose so that you can, when people come back and their recollections differ, I can say, well, they can say I never disclosed it, but here's the email I sent them, and here's their reply saying, yes, I understand, thank you very much. Or here's the piece of paper I had them sign. That's what you want.
This has been very helpful.
Good.
I mean, I'm gonna probably have to have some more conversation with Cheryl and Woody, because, I have a company that is a developer. One of the reasons I'm here is wanting to bring our projects, we do projects, into Bluewater. I want to be part of selling. Obviously, I know it better than anybody else. I want to figure out how to do that. I can see a little
We
bit.
are going to be finding out the answers.
I mean, we need to know that, because, I want to sit in the property as one of the agents.
Sure.
To help sell.
Yeah.
But I want to.
Well, again, it's all about disclosing your interest in the transaction. I have a relationship with this seller.
I just want to do it up front.
Okay. Yeah.
So,
But yeah, I'll review that new rule on selling your own property and the restrictions on the agency situation. And I think, as I recall, the rule says that it's mainly just requires disclosure, and that it gives the person an opportunity to opt out. I'll have to read it. Yeah, I didn't know we were going to go into that, so I wasn't really prepared.
This group will give you pretty much
A
everything.
lot of, and if there's one thing about commission's rules, history will show, once you get to where you understand them, they change them. It's like the standard forms, right?
Yeah.
Right when I finally get to where I'm comfortable using the standard forms, they send out a new batch, so it's the same kind of thing. All right, that it?
Thank you.
Thank you very much. Cards are over there. Please, again, call with questions. That's fine. I'm happy to help you out. Like I said, when I'm teaching, I can't pick up the phone, but I'm good about calling people back and returning